Good afternoon, Mr. Campbell.
Good afternoon, members of the court. May it please the court, my name is Richard Campbell, and I am counsel to the plaintiffs and appellants, in this case the Juliano family, including the minor Rachel Juliano. The issue before the court is framed as follows. Does an underage adult who knowingly and intentionally allows other underage adults and or minors to possess and consume alcohol illegally on premises under her control owe a common law duty of care to others who foreseeably may be injured or killed as a result of her actions?
Could I just ask you one procedural question? We have before us a 54B final judgment on 3 counts of the Fifth Amended complaint.
Correct.
Is that right? Are the other 2 counts still in existence?
Yes. Yes. As a matter of fact, the application for a 54B entry of final judgment was made on 3 separate occasions to 3 separate Superior Court judges, and 2 of those judges denied the application. Judge Donovan, after a hearing on a different case involving coverage, apparently went back to the Superior Court file, made a determination to write another opinion, and entered final judgment.
Okay. But so whatever decision we have, there's still more remaining in this case?
Indeed, including count 2 of the original complaint, which was now made part of the Fifth Amended complaint, and count 2 of the amended complaint raised the very issue before this court. For whatever reason, Judge Donovan only addressed, in her opinions, counts 1, 3, and 4, not count 2. So count 2 is still out there, not subject to her determination, at least not explicitly. I would concede that she probably intended to reach count 2, but did not, in fact, reach it. So it's still out there, along with the counts against the liquor store defendants. Yes.
Okay.
So the case comes to you in a procedurally awkward mode, not through any lack of effort on the part of the Julianos to get it right. But
so turning to the question as you framed it.
Yes.
Did we? Maybe it is in a footnote, but didn't the I've got to get the name right. The Nunez. Didn't we kind of answer this question as you framed it?
Well, it's interesting that you bring that up. Nunez is the case where Justice Gantz, as still in the Superior Court, wrote an opinion effectively saying that one should not treat 18 to 21-year-olds any differently in liquor liability cases than treating a minor. And then the case came before the SJC, and Justice Spina wrote the opinion for the court. And in that opinion, there is a reference to Chapter 138, Section 34. There is a reference to it.
As amended.
And the authority for the proposition stated in that opinion is the Simpson case from the appeals court. And Justice Lenk was a member of that panel. Justice Grasso wrote the opinion. But if you go to the Simpson case, there is no consideration of the 2000 amendment, which we put before you today. There was no consideration at all. And if you go to the briefs that were written in Simpson, there wasn't any discussion of that. So what I would say is the dicta that was appended to the Nunez case, because it certainly wasn't required as part of that ruling, really shouldn't prevent this court from addressing the fundamental question before it now, a question that's always timely and always relevant, and that is whether or not there's a duty of care, given the changing values in society, the changing rules. Is there a duty of care in these circumstances? And the principal test, this court has said in the Jupin versus Cass case and many, many other cases, the starting point in that evaluation of whether or not there's a duty of care, doctrinally, the starting point is a default position that we all owe each other a duty of care.
If you're right that an underage, that a minor can be held responsible to have a duty of care, would at what age, how young would we go?
It's a fair question, and that question came up on the criminal side in Commonwealth versus Nerum in front of I'll remember the name of the judge who wrote that opinion, but Commonwealth versus Nerum, that was a 19-year-old who was charged under this statute for allowing other underage people to possess alcohol under property that he controlled. And the court then asked the question, well, what is the limit with respect to this? Because Nerum was claiming that the statute only applied to people over 21 years of age and not applied to him. The court ruled against him in an opinion that I think is quite sound. And in that opinion, the court looked at other circumstances where the legislature chose the pronoun whoever as the operative word to define the class of people who are governed by the statute. And if my memory serves me correctly, the judge who wrote that opinion found at least one circumstance where that pronoun had been applied to a 14-year-old.
So under your view of what the duty is here, this duty, Jessica Simpson would owe this duty even to people that are over 18 but under 21 who drink on their own volition, bring their own booze to the house, and go out and injure themselves.
Yes. Yes, I think that is and should be the rule. I think the argument...
And that would reverse our precedent, of course.
Indeed, the case law on this topic, most of which dates back to 1991, 92, and 93, before the change in the statute before this court.
So this statute changes everything, in other words. This statute is now a formal and absolute pronouncement of what societal expectations are and that we should follow suit in terms of common law duty.
Well, I think this court has the duty and responsibility to determine the common law. But in determining the common law, I think the jurisprudence of this court always looks to statements of public policy. And that statute, as amended as an emergency act for the public health and safety of the people of the Commonwealth, is a clear-cut policy statement by the elected representatives of the people, signed into law by the government. I don't know how the court can ignore that statement of public policy. And even if you did, even if you choose to ignore that as a statement of public policy, the question of duty is always timely and always relevant. It's in fact appropriate that here we are on the first day of school arguing this matter before this court. This court can take it to the bank that underage drinking parties will begin anew, that underage drinkers will go to private homes out of the purview of public authorities, that they will illegally consume alcohol to great excess. They will do so by engaging in the types of drinking games that went on in this particular case. They will get to the underage drinking party driving, having consumed alcohol. They will become much more willing to confront aggressive behavior, and they will drive off, creating a risk of harm to themselves and to everyone in the Commonwealth.
Do you take...
And that's always been the case.
It has. Sadly, it has been the case.
Do you take anything from the fact that as I understand, that the legislature has rejected the idea of adding specific language for civil liability to this statute?
We addressed that in our reply brief, and I don't take anything from that inactivity. If one looks at the number of bills that are delivered off to the legislature, if one takes into consideration the fact that our legislature allows citizens to file petitions, and then you look at the number of bills that actually are considered by the legislature, I think you will conclude, I submit you should conclude, that really nothing can be taken from that action at all. The flip side of that might be that when the legislature considered the changes to Chapter 138, Section 34, in the aftermath of an underage drinking party in Cohasset that led to the automobile accident that killed Gregory Smith, a 19-year-old, when the legislature was confronted with those circumstances, the legislature would have been aware of the precedent that Justice Cordy referenced, the 91, 92, 93, 94 cases. The legislature could have taken into consideration the common law, as stated by this court, of no duty of care. But the legislature didn't do that. The legislature went ahead and legislatively created a clear-cut duty of responsibility on the part of anyone who utilizes a private premise.
Well, they created a criminal statute making it criminal.
Yes.
I thought the point is that they could also, acknowledging and recognizing how we had applied the common law, could have changed the common law by simply adding a civil remedy as well.
Clearly, the legislature could have done that. It would have been unusual. Our legislature typically does not do that. Our legislature leaves to this great court the determination of common law.
But haven't we, in a sense, traditionally rejected the approach that you're taking, Crimmins versus Clancy versus DeChristopher, and the creation of a criminal statute does not create a per se civil liability. You may be able to use the violation of a criminal statute as evidence of negligence, but that's as far as it goes.
True enough. This state does not operate on negligence per se rules. This court determines common law duties, has traditionally done so, and in doing so has looked to legislative policies as framed in statutes enacted by our legislature. That has always been the case. 25 years ago, when I came before this court in the Langeman case and presented to this court the proposition that the utilization of a private home as a venue for private drinking parties was problematic and should lead to a duty of care, this court rejected that on the notion that the owner of that home was not physically present and didn't physically deliver the alcohol to young Hathaway, who slammed into that Roman Catholic nun. But the court did, in a footnote, if you turn to the Langeman case and you look at the footnote, you're going to find the court said, well, if somebody illegally furnished alcohol to Hathaway, and that could be proved, that would be a violation of 138, Section 34, and that would serve as evidence of negligence. 14 years after we presented the Langeman case to this court, the legislature changed the statute, adopted in a sense, the position that we advocated in the Langeman case. And I submit, if one looks at that Langeman opinion in that footnote and applies that very logic to this case, the court will conclude there is or should be a duty of care, and the violation of that statute should be taken into consideration in evaluating whether or not the defendants were negligent under the circumstances.
Now, but wouldn't that be true in the case? I guess what footnote 2 says is still applicable. A violation of, in this case, Section 34, could be evidence of negligence, but that's sort of a general proposition, isn't it?
It is a general proposition, and it begs the question of whether or not there's a duty. You don't get to present evidence of negligence without this court determining that there's a common law duty of care.
I don't read that as anything more than stating the general proposition.
Maybe I oversold the point, Your Honor.
Well, it just says a violation.
I just find it ironic that 14 years after we presented that proposition to this court, the legislature changed the statute to accomplish what we were trying to accomplish in the Langeman case.
Go ahead.
The duty you mentioned, let me give you an example. Person goes to somebody's home with a case of beer. Person says it's a violation of law for you to do that. I want you to leave. Person says, forget it, I'm going to stay. Breach of duty?
No breach of duty.
So the person is not required to evict that or to eject that person as long as they don't allow it.
You're asking about breach of duty, and breach of duty is always reposes in the jury. So if we get beyond the question of whether or not there is a duty.
As a matter of law, I mean, if somebody comes to my home who's 19 years old and much bigger than I am, and I say leave, and the person does not, breach of duty if I do not call the police, or am I obligated to call the police?
I think that you would be obligated, if there is a duty, to exercise reasonable care under the circumstances. It might well be that part of reasonable care would be demanding that the underage person leave your home. It may well be that reasonable care would mean picking up the phone and calling the police, who are the experts in these circumstances, to come to your assistance. All of those could be considered as reasonable care. There is the Rhode Island Supreme Court in the Marciano case looked at that question of what are the duties and obligations, and that case is cited in our papers. But In that case, the assertion was, well, gee, it would be really difficult to ask the person in control of a property to take steps to prevent illegal underage drinking. The court said, and I'm quoting, "There's no valid justification for absolving an adult parent of this standard of care when she knowingly provides alcohol or is aware that it is available to underage individuals for consumption on her property." And they go on to say, "To avoid assuming a duty of protection, the adult property owner must simply comply with existing law and refuse to provide alcohol or condone underage drinking on his or her property. Therefore, the consequences of imposing such a duty in cases such as this are not economically and socially staggering," which was argued by the defendant in that case. The court held they are, in fact, negligible. I see that my time is up. I very much appreciate the opportunity to appear on behalf of the Julianos. Thank you.
Thank you.
Good morning, Your Honors. Robert Powers on behalf of the appellees Peter and Jessica Simpson. Here today to ask the court to affirm the judgment that entered in their favor below and remand the case to the Superior Court with direction that judgment enter in their favor on all the claims that were made against them.
Haven't we come a long way? I mean, doesn't this criminal statute really represent decades of internal debate, discussion, social development, and recognition of the great harm that such events can cause? And shouldn't we be recognizing that in our common law?
It absolutely represents a recognition on the part of the legislature that underage drinking is a serious problem. But it says nothing about whether or not there ought to have been or whether or not the legislature intended to frame a civil remedy. That statute, the preamble of the statute says it was an emergency in order to strengthen the criminal statute. And in that case, it came out of the situation where an adult knowingly, intentionally provided their home for underage individuals to consume alcohol, despite the fact that the legislature has over many years said that underage individuals ought not to be doing that. We've raised the drinking age from 18 to 20 to 21, and despite that, in that situation, you had individuals, parents, adults out there saying, well, better to drink at home than to be drinking in the parking lots or in schoolyards. It's a criminal statute, Your Honor. And this court has time and time again looked sometimes to the criminal statutes as informing its judgment as to whether or not a duty should or should not exist. But in this case here, Your Honor, the legislature didn't say that. That's for this court to say. And when it comes to social host liability, a particular type of liability, and it's always been recognized as a particular type of liability, right back to the McGuigan case when it was first originally recognized by this court. And the court said, we're going to look at this on a case-by-case basis.
What have other states done in this particular field?
Your Honor, the states are quite divided on this. About a third of the case, the states recognize social host liability in certain circumstances. About some of them have rejected social host liability. With respect to a situation like this where we have an underage individual, such as Jessica Simpson, providing alcohol, I understand.
Not providing, I take it. Are you saying providing
not
or just
not providing, providing a location where the drinking occurred. My understanding, Your Honor, is there are about 3 states, I believe it's Colorado, Michigan, and I think Florida, who have addressed the issue and indicated that there would be no liability.
Well, is this because it was an underage person who provided the location? I mean, is that determinative in these states? If it had been an adult, would the outcome be different in those states, or how are they fashioning when the duty applies?
Well, Your Honor, I'm in no position to figure out or offer comment on how these other states are going to determine it.
But the 3 states you mentioned, they are all talking in terms of an underage person, whether an underage person has a duty in these circumstances versus whether an adult. I mean, we were just hearing about an adult parent in Rhode Island having this duty, but are you suggesting these states say that an underage person doesn't have the duty, but maybe the adult does?
What I'm suggesting, Your Honor, is that when the court surveys the status of the law on social host liability across the country, you're going to find that various states are divided in their approaches.
Okay.
And that the
fair enough.
approach that we have here in Massachusetts that focuses upon the individual who supplies and controls the liquor is the appropriate focus when it comes to determining whether or not a civil duty ought to exist. No argument is made in the appellee's brief with regards to Peter Simpson.
Okay, but we're talking about Jessica, so.
Right, we're just talking about Jessica.
Peter should be entitled to a judgment as a matter of law based upon that. But Jessica, too, did not supply this alcohol. It's
Right.
undisputed. The alcohol here was illegally obtained and transported in Rachel Giuliano's car to Mr. Simpson's house.
Right, but doesn't the law recognize that providing a safe haven in one's home for a person who is underage to drink is dangerous enough to make it a crime?
Your Honor, Section 34 in that amendment says that providing a location is enough to make it a crime. But 34A says that the purchase of alcohol by an underminer is a crime. And 34C tells us that the transport is.
Do you disagree that Jessica Simpson could be prosecuted?
Jessica Simpson was not prosecuted.
I know she wasn't. I asked whether you think she could have been.
Your Honor, she potentially could have been prosecuted under that statute. I think that there is a criminal case already recognized where an underage adult who had provided the location was prosecuted. The appeals court said it was a very unfortunate circumstance, but they also said the legislature, in determining what is criminal, has said that anyone who provides the location is subject to the criminal penalties. So certainly Jessica might have, but she wasn't.
Okay, so why is it onerous to impose that duty upon her? She already has a duty under the criminal law.
The criminal law is the criminal law. It is not congruous with the civil law. The civil law, while informed by, in cases, the determination of the legislature to make certain conduct criminal, does not necessarily follow from that this court
Okay,
needs
but
to
that's not my
recognize
question.
civil.
My question is, why is it onerous to impose a duty under the common law, which is no greater than the person's duty under the criminal law?
Your Honor, it is onerous because you're shifting the focus away from the supply of the alcohol.
No, they're liable too.
Well, then you're undercutting the deterrent factor. I mean, Capadano's, the liquor store who provided the liquor here, is now going to be looking to Mr. Simpson and Mr. Simpson's homeowner's policy in order to share in the responsibility that it bears for selling that liquor, that 30-pack in the Bacardi, to Mr. Dunbar. The question here, Your Honor, is whether or not Jessica Simpson owed a duty to Rachel, whether Rachel is entitled, her interests are entitled to be protected by this court recognizing a duty, and that is driven by the facts, Your Honor. And on the facts here, Jessica had no reason to understand, okay, or to appreciate that that she had to take some particular duty with respect to Rachel in the circumstance of this case, just as if Rachel should not have been reasonably looking to Jessica to protect her.
Right, but you didn't prevail on summary judgment on the grounds that it was not foreseeable or that it was not clear that the person who drove the car was drunk. You prevailed because the person said there's no duty.
We prevailed because the case law handed down from this court and the appeals court has consistently said that there is no duty if there is no supply in the social host situation. That is why we prevailed here.
But you can't say that she relied upon that because she arguably committed a crime in doing it. So, I mean, you can't do a reliance argument, can you? That she relied upon the absence of there being a common law duty when she indeed violated the criminal law by doing it?
The question here, Your Honor, before this very court is there a duty? And the question of whether or not there is a duty turns on the circumstances of the case and whether or not the individual who is claiming that their interests should be protected had a reasonable right to look to the other individuals who take affirmative action, and whether or not the person who was to take the affirmative action reasonably should have understood that they had to take the affirmative action. So the question here is duty.
Explain to me the difference between these two cases. Simpsons say to their kids, hey, you can have a party at our house. We're not going to supply any alcohol, but if kids are going to bring their own booze, that's okay. With a situation where two people show up with booze, unplanned, and then the Simpsons don't tell them to leave, but allow them to stay and drink. How do they play out in terms of a civil action? Is there one of those? Does one of those two cases pose a greater situation for liability from your perspective?
Well, first, I think it's important to emphasize that Mr. Simpson made it clear that there was to be no underage drinking on his premises. But assuming that we're talking about, in the abstract, parents who do that, I don't know that there is a distinction, because the adult who says you may party at my house and you may have alcohol is in not much better situation than the adult who says, you may party at my house, I'm not going to provide alcohol, but it's all right if you bring it. In both situations, that adult should know, that they are creating a situation that is likely to lead to tragedy.
But you're suggesting, I thought, that they would not be liable because they didn't supply the alcohol.
The situation on the civil side of things, Your Honor, if you do not supply the alcohol, then there ought not to be social host liability. Justice Spina's question, I understood, was directed to...
We're being clearly asked to change that. I mean, there's no question that under our prior cases, I don't think there's any question that there is no social host liability here. So we're being asked to
You're being asked to change it.
Because
You're
of
being asked to
the
change it.
criminal statute, largely because of the criminal statute.
And under the version of Section 34, which imposes criminal penalties for providing a place for underage individuals to drink. If you own or control the property, then I believe, Your Honor, in those circumstances, that criminal liability would attach, and from that criminal liability would flow civil liability. But the circumstances here, and the law must develop on a case-by-case basis. And if we look at what Peter did here and if we look at what Jessica did here, neither one supplied that alcohol. They were entitled to summary judgment based upon all of the jurisprudence, all of the cases handed down by this court that say that we need to focus. If we abandon the focus on the supply of alcohol, then in the civil context, we are eliminating what right now is a very practical limit on individuals understanding what their civil duty is.
But isn't there a practical difference? I mean, one of the reasons which Justice Graney mentioned is that if somebody is drinking at your home and they brought their own, and you see that they're getting drunk, if you were to be liable without supplying, you can't control how much the person drinks. You'd have to, you can't say, I'm giving you no more, or I'm taking away the alcohol. But here you do have the ability to say, I want you to leave.
Your Honor, the ability to say, you have to leave just pushes the problem someplace else.
But that's the same obligation you have under the criminal statute. You have to say, go. Otherwise, you risk criminal liability for the underage illegal drinking happening at your house.
Absolutely, Justice Lane.
So there's no difference in what you're required to do.
Your Honor, there's a difference insofar as whether the criminal liability.
I'll take a risk of, I won't be, I'll take the risk of being arrested, but, that's better than I'll take the risk of not being sued.
Your Honor, if the criminal statute set forth a civil remedy or said that a civil duty existed, then we wouldn't be here. This court has the responsibility to determine what the contours of civil liability are. And the civil and the criminal are not in all respects the same. If we abandon the supply of the liquor when it comes to social hosts, then we open up homeowners to a myriad of situations. Because the statute, the statute uses the word knowing or willfully. Knowing is a question of fact. Control is a question of fact. Counsel, in their brief, turns to a criminal statute in which an adult was held responsible for, under Section 34, for controlling a campsite, wasn't even his own property. So if we're going to shift the focus to the control of the property and away from control of the liquor liability, then we are opening up a liability that's going to be very, very hard for homeowners to understand or to draw the line. Your Honor, even last year in the Lev case, we were called upon to address the issue with respect to an employer. The issue of how to draw that liability. Duty circumscribes liability. That we have to be able to draw that line. We have to be able to draw it practically.
All right, thank you very much, sir.
Thank you, Your Honor.